Right, this question's looking at the appeals from the civil courts then. So you just need to be aware of what the question's asking you to do, because obviously you've looked previously at appeals from the criminal courts. Okay. Right, so in civil cases it is possible for either party to appeal. So this is sort of just your introduction really. So you can appeal on a point of law, a dispute in terms of how much money was given, the facts of the case, but you also need leave to appeal. So the first and last one you've done already. So a point of law, you're arguing that the law has been misapplied or misunderstood. So it could be that you're arguing some form of personal injury claim, and that aspect of negligence or personal injury, the law that they're using, has been misapplied or misunderstood. You do need permission then in order to appeal. Now, an important point about this question, because it's similar to the other diagram, you can in fact draw it to get the marks, okay? So just get it to size, sorry, there you go. So you can draw it should you wish to draw it in the real exam, okay? If you do so, you do need both sides. So this side would get you your first 9 marks, on average anyway, and the second side would get you the other 9 marks. Right, so basically from here down, the one important point to remember about the civil appeals is that you're not just going from court to court to court to court. The civil appeal route is all about going judges rather than courts, okay? That's the key point, that you should be going up in terms of judge level, not court level. Right, so as you can see there then, small claim and fast track claims that are heard by a district judge on appeal will go to the circuit judge in the county court, okay? Now, when I taught it, I went the other way around, so I said fast track and small track cases heard by a district judge will go up to a circuit judge instead, if they're heard by a district judge initially, okay? Now, what you need to do is make sure that the detail that we've given you is included. It says there, the right to appeal against these decisions in small claims courts have always been around, well, always since 2000, sorry. So it was to comply with Article 6 of the European Convention on Human Rights. So just to make sure everybody gets a fair trial, all small track claims and fast track claims can be heard on appeal. Alright, you can appeal them up if you want to. Right, then, as you can see, separate appeal if the fast track case is already heard by a circuit judge, right? So if your fast track is already heard by a circuit judge, it will go up to the next level judge. Now, in terms of judges, you get district judges, circuit judges, high court judges. So even though these two are in the same court, your high court judge is in the high court. So you are going to a different court if you do this sort of second appeal. In that sense, but you just need to be aware that you'll normally go through judge and court. So the only reason that the fast track case goes straight to the high court is because it's already heard by the top level judge in that court. Okay, circuit judges are the top judges in the county court, so if they've already dealt with it, clearly the only way is to appeal higher up. Okay. Finally then, it will take that further appeal to the Court of Appeal should you wish. Okay, so you'll go from fast track cases, you'll go for the circuit judge. Once he's heard the case, you can appeal to the High Court judge. Should you need a further appeal, you can do it again to the Court of Appeal. Okay, but it's got to be some form of exceptional circumstance. So as it says there, an important point of law, principle, practice, or some other compelling reason. Finally then, if a multi-track case is dealt with in the county court, it will automatically be appealed to the Court of Appeal as a result. Okay, right, so what you just need to be aware of here then is making sure you're going through the judges correctly, okay, and that you go up from one appeal to the next. Right, appealing from the High Court then. So if your case has already been dealt with by the High Court, so it would be anything that's £50,000 plus, or anything that's very, very, very complex, that would get dealt with at the High Court, okay? Now, as you can see, it's a little bit more straightforward than the other side, really. So you're going in the arrows. So if your case has been heard by the High Court, it will go to the Court of Appeal. Now, at the other side, we're looking at going from judge to judge to judge before we went to the next court up. These sort of courts would normally just have your standard judges listening to the cases. So you just go from the High Court straight to the Court of Appeal. There'd be no sort of judge in between. You just go from the High Court up to the Court of Appeal. Now, the Court of Appeal in our hierarchy is kind of split in two. So it's got a criminal side and a civil side, which is why you've seen this court mentioned before in the criminal court hierarchy. Alternative way of appealing, obviously for criminal cases, right? But we're more interested in civil here. So you're going up to the Court of Appeal, right? And then you would do a further appeal to the Supreme Court should you feel like you need to. But as we've done with the other one, it's exactly the same. If it is a point of law that is of general public importance. Now, obviously, this has got to be a civil point of law of general public importance, but that is how it would go. Okay? Now, as you can see then, at the right-hand side, you've got this big arrow. This is here because it is suggesting that we could have a leapfrog situation. This occurs when you are appealing directly from the High Court up to the Supreme Court. So, in essence, what you're doing is you're sort of missing the Court of Appeal out in that sense. Okay? So, rather than go through the normal process, this court is going. Okay, now the reason for this, as you can see at the right hand side, there's a few things that could be relevant that I need to explain to you. So first of all, one of the biggest reasons why you would appeal directly to the Supreme Court is if the Court of Appeal is bound by its previous decision. Now, you'll do a bit more of this in Unit 2, and it'll probably make a bit more sense then. But in our court system, we have a hierarchy. Some judges are allowed to change their own minds. Some judges are not. So if that judge makes a decision on that day, they're not allowed to ever make a different decision. Right, they've got to stick with it forever. Whereas other judges in other courts can change their mind on a daily basis. So the Supreme Court, for example, they could make a decision tomorrow morning and tomorrow afternoon they could change it and make a different one. Okay? Whereas the Court of Appeal is bound by its own decisions. So the Court of Appeal has to follow its own decisions. Right? So if it made a decision tomorrow, for the next 1, 10, 100, thousands of years, it has to follow its own decision technically. Okay? So, if it is bound by its own decision and you know that that court is not going to decide anything else, why bother appealing to it when you're just going to get the same outcome? So this whole process of leapfrogging is preventing you from being stuck here and them saying the same thing again and again. Okay, so they are going for a leapfrog straight to the Supreme Court. The Supreme Court is allowed to change its own mind. So if it did want to make a new decision, clearly that is possible. Okay, so that's one reason. Another reason to leapfrog is if statutory interpretation is involved. Now, statutory interpretation occurs on a daily basis, right? Basically, what this means, a statute is a law that Parliament makes. So when statutory interpretation is occurring, it's basically judges trying to interpret what Parliament have said in that piece of law. So Parliament might make a new law on negligence, so it's all about them trying to work out what Parliament was saying when they made that law on negligence. Okay? Now, again, because it's them trying to work it out, and it's quite detailed and difficult, to be honest, to work out what Parliament are saying sometimes, because they don't write in language that you and I will understand. They'll write in legal jargon, basically. So if it involves statutory interpretation, these are your best judges to be interpreting, because they are the top judges in our country. They are paid a lot of money. They have a hell of a lot of expertise. So again, don't go to these guys that might not really know too much about it. What we are saying instead is leapfrog directly to the Supreme Court, because they can do the interpreting instead. Okay, so normally you'd go through this straight format: High Court, Court of Appeal, Supreme Court, unless you want to leapfrog because of those reasons. Tanford, basically, you just need the first word. Tanford is an important case because it told us when we can appeal in civil cases. So it said that we need permission to appeal, and it said that we need to make sure that we only do one full appeal route at once, to make sure that we are obviously just doing what needs to be done. Okay, and you should only be appealing in exceptional circumstances. Okay, if it's really pretty obvious that that trial judge has messed up, that initial judge. If you want to appeal further, you can do, but it's got to involve European law. So if you get to the Supreme Court, you're still not happy, you want to argue a point of European law, let's say it's employment, because a lot of our employment laws are from Europe, then you would go and do a further appeal, so you just add it to the end, European Court of Justice. You'd only do it if it would be an important point of European law that you are trying to argue. Okay, so it is an 18-mark question, and you need to make sure that you are giving the extra detail that is at the side, okay? Because you can't possibly just get your 18 marks from just drawing the diagram out, okay? You've got to make sure that you are giving it as much detail as possible, okay? Now, if I just add an extra slide. Yep. Right, so your question will want to know how civil appeals are dealt with, basically, okay? Now, obviously I've taken you through the diagram there. When I did it in class, I drew it out slightly different. So I'm just going to recap to you how I did that, just to make sure that you know what to do, okay? So if you want to follow the other diagram that I've just gone through, brilliant, follow it, it's right. I just think you need a little bit more basic, really, in that sense. So small claims cases and fast track claims cases. Sorry, a bit tongue tied. If that case is dealt with by a district judge at first instance, you will appeal it up to a circuit judge. Now, these are both still taking place in the county court, right? So this is still the county court and this is still the county court, because we are going up senior judges. We're going from a lower level judge to a more senior judge. So you will appeal up. We've been allowed to do it since the year 2000, so it's pretty much all right. Okay. If it is a fast track case that's already been dealt with by a circuit judge, you can't then obviously appeal it to a circuit judge again. So what you are doing this time is you are going up and you are appealing to a high court judge in the high court. Alright, again, you're going up senior judges, but the only difference is here is that the next level judge up is in the high court. Okay, and if you needed to, you could make a second appeal to the Court of Appeal, and again, that judge is in the Court of Appeal. So you're going up, even though you're going to a different court, it's only because the only option is to go to the Court of Appeal, because the next sort of judge is the Court of Appeal judges. Okay, so that's that aspect. Let's just move this up to add some more room on. Your final bit for that first scenario was that if it is a multi-track case, it will go straight to the Court of Appeal, okay? So multi-track cases that are initially heard in the county court will go up to a Court of Appeal judge in the Court of Appeal, okay? And again, they will be dealt with there. So this is still your first sort of diagram. I've just split it slightly into 3 different areas so that you're not just doing this one, I suppose, as a full big route in that sense. Okay, now your High Court appeal diagram stays exactly the same. The only reason I have done this is to try and simplify it down into, right, small and fast track dealt with by this judge goes here. If it's this judge, it goes here, with your option for your further appeal should you need it to go higher up, but you might not need it. And then obviously your Court of Appeal appeal route for any multi-track cases. Okay, just do not forget you need to make sure you give the detail. It isn't as bad as the criminal court appeals, but this is a very highly possible question in your exam, and it is a popular one, so you do need to make sure that you are prepared for it. Okay, should you want to write it, you can do so. Feel free, you could write it out properly. You will have probably been given the specimen answer for writing out by now, but obviously that's something that we can do. Okay.